So one of our recent clients, who's a landlord, came in recently for legal advice on an issue she had with one of her rental properties. She had a tenant that she had received an eviction judgment but hadn't actually gone to remove the tenant, and when they went to do that, the tenant had already completely vacated the property, but he had left all of his stuff there. Apparently this tenant was a handyman and liked doing woodworking, and he had thousands and thousands of dollars of very high-tech woodworking equipment and a number of all types of tools filled in the garage, and the whole house looked like a warehouse in the garage, our client told us, and she didn't know what to do with this property. Since he had already vacated, she didn't have a forwarding address or any way to contact him. And so, there's a couple things that need to be considered in that situation. And primarily, the first thing you want to do every time you have an issue regarding a residential lease or commercial lease for that matter is you want to pull out the lease. You need to review the lease because that's the controlling document. And if the lease states how to handle that specific situation, then you follow what the lease says. But there are times when the lease is silent on that issue and doesn't address what to do with what we would consider abandoned property. And so there's actually a process that the landlords need to follow to make sure that they don't get themselves in hot water by either taking valuable property and using it for themselves if the tenant has left it, or maybe thinking that, oh, this is all junk and I'm just going to dispose of it and trash it. Generally, whenever the lease doesn't govern this area, the landlord is going to need to post a notice, try to send notice to the tenant in some way. The weird thing about that is that if there's no forwarding address, the last known address is where the landlord is required to send the notice. And so that might end up being the property that they don't live at anymore. But you have to send the notice. If you don't hear from the tenant, you have to take the property and move it to a storage facility and keep it generally for about 30 days. And you need to send a notice telling the tenant at whatever address you have that the property is being stored so they can come recover it. As long as they cover the fees and any costs that the landlord has incurred in moving and storing that property, then they can get the property back. Since this client had a bunch of very expensive property left in her rental property, basic necessities. I mean, the guy looks like he left without taking any of his clothes. I mean, he just left everything there. We sat down, we looked at her lease. Luckily, her lease did have a provision stating that she did not need to send that notice. That notice was waived and that she could fully dispose of the property any way she saw fit. And so that was an easy resolution for that client, but it's not always so easy. I have had clients where valuable property was left and the landlord did get in trouble because they didn't follow the proper procedures for disposing of it or sending notice. So it's important to always read your lease. That's one of the things we see overlooked more than anything. That should always be your first step. Pull out the lease, read through the lease, see if it covers this specific issue. And if not, just schedule an appointment with an attorney and we'd be happy to help you if you gave us a call.